CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS
Talk to
Talks.
me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like that morning. They don't talk to me. That morning. They don't talk to me. That morning. They don't talk to me. That morning.
Welcome back to the CLS Talks, our intermittent radio program podcast, our general conduit of information for those that might be interested in what it is we speak about. I'm very pleased to be joined by Des Carty again. Des, how are you?
I'm grand, Lionel, and yourself?
I'm very good, thanks. In fine stead, and we've had some very interesting information over the last weeks, months, and since we spoke together on this show. And we're going to delve into some of that on today's show. So, most specifically, the circuit courts. There's been a bit of a shake-up recently in that there was a case a couple of weeks back, or an appeal in the High Court, relating to a civil bill for possession, whereby an appeal was granted, but this appeal had challenged the jurisdiction of the circuit court.
Yeah.
And it potentially has some far-reaching consequences for anybody who might be in the same position and currently dealing or trying to avoid dealing with a civil bill for possession. So, very briefly, tell us a little bit about what happened.
All right, Lionel, perhaps we should sort of explain what a civil bill is.
Good idea, actually, yeah.
There's probably a lot of people out there who aren't sure what a civil bill is. A civil bill generally is when a banker tried to take your home, there's two ways they can deal with it. They can go to the High Court and issue a summons to get you into the High Court for a money order or a possession order for that matter. Or the bank can simply go, at the moment, and it still stands, they can still go to the circuit court seeking what's called a civil bill for possession,
right,
which is a possession order. And the civil bill doesn't relate to the value of the property per se. What they put it down to is what's called rateable valuation.
Okay, so tell me a bit about that, because I'm not entirely au fait with rateable value.
Okay, so what they're doing is, which is incorrect, but this is what they have been doing over the years and recently, is they have been looking at the property that you live in, which is your home, and they have been looking at it as a commercial property.
Okay, now that doesn't make sense to me off the bat.
Yeah.
How can that be?
Okay, they do that simply because with the commercial property you can put what's called a rateable value on it. And the rateable value is a value at a very low level, and then you multiply that up into the proper value. But if they put a rateable valuation on the property, it's usually in the couple of hundred region or the 100 region. So that means that they can bring it to the court without the court considering within the jurisdiction of the court the value of the property per se. So the circuit court's value, I think it's in the region of up to 75,000 euros, thereabouts.
Yeah.
So instead of saying to the court, well, the property is actually valued at 75,000 or above, so therefore we can't bring it into this court, they say, well, the rateable valuation is maybe 230 euros. So therefore it qualifies for us to bring it into that court, the circuit court, in order to seek a possession order. They're not seeking for reclamation of a money order as in the value of the property per se on the open market. What they're seeking is that they get possession of the property, which has a null value really, and then what they'll go and do laterally after getting the order is to sell the property.
So that to me seems like some form of legal trickery or mathematical trickery, in that for the purposes of getting somebody into court to try and take their home, they're saying, right, well, it's actually worth nothing. Thereby, we are abiding by the rules set out in the circuit court, so let's get it in here. And then afterwards, once we've got what we want, we suddenly magically value it up again so we can sell it on.
Yeah, that's exactly the trick. Now, you might say it's a trick, but it's not a trick, it's a scam. It's fraud, really, and people have been challenging the validity of that for quite a substantial amount of time. And the specific case that we'll refer to today, I'll quote it verbatim what it says on the order of the court, or on the judgment of the court. It says, the judgment of Miss Justice Murphy, delivered on the 20th of May 2015. So as you say, Lionel, it's very, very recent.
Yeah.
So the opening paragraph of the judgment is, this judgment concerns the jurisdiction of the circuit court to hear the plaintiff's claim for possession of the defendant's domestic dwelling, it says. Okay, so that's your home. So this case was heard in the circuit court, and the circuit court, although they were told that the circuit court do not have the jurisdiction to hear the case, went ahead and proceeded in the case and gave an order to the bank for possession, although they had knowledge of the fact that the court did not have the jurisdiction, was not capable legally of hearing the case. The judge in the case still heard the case and granted illegally and unlawfully an order for possession.
Okay.
Now, luckily, these people were cognizant and wary enough to go and appeal this issue. And the judgment in the High Court, which was the appeal, heard by Ms. Justice Murphy, she said basically, well, the circuit court did not have the jurisdiction to hear this case because this was not a commercial property.
And that's the crux of it then, because commercial versus residential, that's really what we're talking about here. So, I mean, that rule applies to commercial or business properties, but not your family home.
Correct, your home. Your home is your home. As they've put it here, domestic dwelling.
So it reminds me a little bit, if I'm a soccer player and I'm playing the FA Cup final, and a basketball referee is overseeing the proceedings and allows the opposition to handle the ball. I mean, that's against the rules of soccer or football, not basketball, but that referee should never have been there in the first place, so that game shouldn't have taken place. That's what it reminds me of a little.
You've actually pinpointed, as part of the article we put out last week, you've pinpointed the specific issue at hand. It's not so much that the bank did or did not go into the court, it's the fact that the court themselves and the judge, in the case, the same as the referee should not have been there adjudicating that game. In other words, the judge in this case should have said straight away to the bank, sorry, this case cannot be heard because you do not have the jurisdiction to bring this case into this court.
Yeah.
The judge in this case broke the law.
Okay, now, presumably that's extremely serious, Des.
Well, as far as I'm aware, Lionel, over the last X amount of years since the state has been formed, no judge has ever been, taken out of office or hung or drawn or quartered or persecuted or prosecuted for their misjudgment or their illegal judgments or unlawful judgments of their judgments. So to get a judge taken to task in this country so far has been proven you just cannot do it.
Okay, so what can the man or woman in this case do then with this judgment or this hearing, because their appeal was successful?
Absolutely, yeah.
So that's the end of that civil bill for possession for the time being anyway.
Now let's qualify that. I'll give you, we want to not just look at the positives, because there is some great outcomes from this case, obviously. But there is also a negative aspect to it, which I'll dig it out here for you now. In that the judge at the time, Justice Murphy, a statement that she made, and I'll read the statement out verbatim and then we'll sort of analyse it as best we can. For the foregoing reasons, the court will allow the defendants appeal on jurisdiction, which was a good thing. So the judge said that the defendants will be allowed appeal on the jurisdiction issue. So they discovered the issue. Now, laterally, the judge turns around and said towards the end of the judgment, there is no dispute that the defendants borrowed the money.
Okay.
And no dispute that they ceased making agreed payments in August 2011. This judgment merely postpones the day of reckoning while their debt keeps mounting.
Now, I find that quite interesting because, I mean, what business does the judge have saying this in the first place?
Correct, absolutely. You see, the judge on one hand is saying, yeah, fair enough, the circuit court did not have the jurisdiction to hear the case, and by law she was correct in saying that, and therefore the case had to be set aside. They couldn't be heard anymore, so therefore the bank cannot go back to the circuit court.
Okay.
Now, by the statement of the judge saying there is no dispute, what she's actually saying is, right, she's allowing the bank to go back into the High Court now to seek a possession order or a money order, depending on which way they want to go. And she's already adjudging that there is no dispute.
So, to clarify then a little bit, I imagine I'm the bank. Can I use that statement by the judge in the High Court to aid my case
Absolutely, because it is set as a judgment now, you see. It's already set a precedent. So there'll be the bank, no doubt. Now, we cannot say for definite the bank will or won't use this argument. But if I was the bank, or if I was a solicitor acting for the bank, I'd be saying, well, actually, Justice Murphy actually said there is no dispute. So therefore, it's a cut and dry case. Okay? And then the judge obviously went on to say the defendants borrowed the money. So again, the judge is now giving evidence.
Yeah, it sounds like testimony.
It's exactly what it sounds like, but that's what it purports to be, because it allows the bank to go back into the court now and say, well, actually, the judge said there is no dispute and the defendants borrowed the money.
Yeah.
And that is always the contentious issue.
Sure.
Whether or not people bring it up or not. Now, the reason, I suppose, the question here is, now, we look at some of the pros of this. Now, the fact that the judge has allowed the bank now to go back into the High Court, the bank probably will go back to the High Court seeking a possession order or a money order in relation to the property. So that's that. Now, what this judgment actually does for people is anybody that's currently in the Circuit Court under a possession order, a civil bill for possession, wherein it actually talks about rateable valuation, or in some cases not, where it's for your home, then the precedence has been set whereby the bank do not have jurisdiction to be in that court, and if they attempt to do so, they're actually breaking the law.
Right, so just to bring out an observation then, thinking out loud, we're talking about a figure of roughly €75,000, which is the cut-off point for the Circuit Court. Yeah. The majority of mortgages that are allegedly not being performed upon would be for a figure far higher than that.
Double, treble, yeah.
So there has to be something used to get these houses and properties and homes into the Circuit Court, and this is the tool that they're using to get it in. So essentially anybody who has a mortgage should be looking at, well, what kind of figure are they looking for? What do they want from you? What are they, in real life, in a sense, valuing your house at? Or what is your house valued at? And then how are they getting that in to the Circuit Court? Because if there's a kind of a discrepancy between the two figures, well, then you might have something to hang your hat on here.
Oh, absolutely. But the key thing to look for, if you get served a summons from the bank, is to look at what they've said and or what it's stated as. If it's a civil bill for possession, that then opens up the door for you to say to the court, and you do need to put it into what they call your pleadings, or inform the court that the bank do not have jurisdiction. But looking at your documents, if you have been served with the summons, and there's ways to legally and lawfully avoid that as well, by the way, but if you have been served with the summons, a civil bill for possession, that is definitely worth looking at and seriously considering writing to the court under one guise or another, or putting it into your pleadings to advise the court that they do not have jurisdiction to hear this case. And if they do, they're breaking the law. And that's it. Now, that doesn't guarantee that the bank will actually bend to that and actually withdraw the case or anything like that. We have heard cases recently in some of the courts, circuit courts throughout the country, that the bank are still going in seeking possession orders on foot of the fact that the defendants have not put it in their pleadings, that the bank do not and the court do not have jurisdiction to hear the case.
Okay, so again to observe, I'm the bank. I've been made aware that I'm up to no good.
Yeah.
In case I didn't know up to now. So I know what I'm doing is wrong. I'm breaking not just the rules but the law. But I'm going to continue regardless, because the person who I am trying to do wrong to hasn't pointed it out in a particular way.
No, you have it. That's it in a nutshell.
Incredible stuff.
So people do need to, irrespective of the fact the precedence has been set, you need to make an issue of it, one way or the other. In some cases, that means putting it into your pleadings, your affidavit, if you lodge an affidavit. If you have a solicitor working for you, it's 50-50 whether or not you can get the solicitor to do this, because most solicitors do not want to work for their clients in that way. They want to. A lot of solicitors may say to you, I'm not saying they all will, but primarily most of them will say, well, it's a foregone conclusion. You're going to lose the home anyway. You might as well lose it today rather than tomorrow in the High Court, which will involve more cost. So that may be their argument, and that's what the judge was actually arguing here, that it's a foregone conclusion. These people are going to lose their home anyway. All you're doing is deferring the day of reckoning. And she actually used the words, the day of reckoning.
Powerful words.
Look, when I read it, I was shocked by what I read because I thought, well, it's a good thing that they have made such a judgment, obviously,
Yeah.
and it will help people. But you have to kind of read between the lines sometimes when you read these judgments. The judges are, from what we can see, and I mean, I'm sure from what you have observed yourself as well, Lionel, they do actually facilitate the banks and the barristers and the solicitors in facilitating taking people's homes and property off them.
Absolutely, and they're quite clever about it in a lot of cases, in that sometimes the person who is defending thinks that they're being helped
Yes,
by the
correct.
judge, when in fact the judge is making statements or testifying in a language that the majority of lay people don't understand, but the barristers or the solicitors very clearly understand what's being
Correct.
said, and quite often they're warning the barristers, solicitors not to go down a particular road or to take a different route. And when some of the cases are analysed, it becomes quite obvious that, I mean, there's some seriously nefarious behaviour going on,
Absolutely.
and there is collusion between the judiciary and the legal professionals.
Yeah, you've seen it yourself, Lionel, when we've given schools and done tutorials and that, and we've analysed court transcripts. And it's only by when you walk away from the court and you have a transcript of what went on, you can actually read what's happened. An awful lot of the stuff that happens obviously very fast. And most people are not tuned in to take cognizance of what is going on. Most people, including myself, I could stand in a court all day long and I probably wouldn't pick up 99% of what's going on.
Yeah.
But it's only when you have a transcript of a record of what's gone on that you can sit down in the cold light of day and analyse, either by yourself or with a couple of people, analyse what was said and what was done in the court. And 99 times out of 100 you'll find that the court has either been led by the barrister or the solicitor,
Yeah.
or the judge has, as you suggest, colluded with that party, the plaintiff, in directing the court in a certain direction. But in most cases, it's against the defendant.
Yeah.
99% of cases, and you've seen, like with us, we've sat down and we've analysed these transcripts, and it's unbelievable some of the material that is contained within these transcripts. Now, we had a discussion before about this, and it may seem a bit harsh and probably not the right words, but a lot of these people are sociopaths.
Yeah.
In those positions. Now, they're very subtle. They're high-functioning, what's called high-functioning sociopaths or psychopaths. And it's only when you analyse in the aftermath of a case what was said, you'll actually read what these people are about. They have no empathy towards the people that are in front of them. All they are interested in is the process of getting you in, getting you out, and taking what they can from you in the meantime.
That's a very important point, and it does come back to the psychology behind how the system works, if you like, or the legal system and the courts, because most of us assume that everybody thinks like us. So we can have empathetic feelings, and we think in a particular way, and we wrongly assume that everybody else is the same. But these people are not the same as us, and when you analyse, it is only when you analyse the transcripts and you forensically go through exactly what's been said and why it has been said in a particular way, that you realise, hang on a minute, there's no humanity involved here whatsoever. This is about an end result. It's almost like agenda-led court cases. So we predetermine the result, and then we will take whatever path is necessary to get to that result.
Yeah.
And to hell with the humanity, and to hell with the real person who's standing there in front of us. It doesn't actually matter. And that's a scary, scary position to be in for anybody. And it's not that we're trying to fearmonger, but we do have to be cognizant of the reality of the situation, because it's only when we get to that point that we can do something about it.
Correct. Well, look, let's finish on a positive note, because the ruling in itself, broadly speaking, was a good thing. We won't deny that. So if you're in a position whereby you're anticipating getting a civil bill for possession, or you're anticipating that they might be bringing you into the circuit court / high court, you should now go and study your documents. Now, there is a fear in that for most people as well. It's not easy, and we know that it's not easy to sit down and look at these things, but it is worth your while doing it, finding the courage to sit down and read these things, and then addressing, be it the solicitors, the court, the judge, writing to them in the cold light of day in your way, and saying, well, look, you do not have jurisdiction to hear this case.
Yeah.
So therefore this case needs to be removed, struck out, withdrawn. set aside, whatever it might be, and keep hammering on with that issue. Now, jurisdiction is a lot more deeper and broader than we're letting on. We might do something on jurisdiction at another time.
Yeah,
perhaps,
I think that'd be worthwhile.
because there's a broader issue. We, as you're aware, we sent out information a couple of weeks back in relation to what jurisdiction is and how to look at other documents that they have put in front of the courts. Now, on a more positive note, people who are now, they think they may be getting possession orders, they must start looking at this, analysing it, read the emails that we send out, so on and so forth. People that are in the court at the moment, they can have their cases set aside, withdrawn, struck out, so on and so forth, providing they put it in some form or another, be it through the solicitor, through an affidavit, or putting in a notice to the court in relation to advising the court that they do not have jurisdiction. And then pressing home the point.
Yeah.
Because if you don't press home the point to the court, they will proceed.
And I do think it's worth noting at this point as well that just because somebody listening doesn't have a legal qualification or has never drafted a legal document before, that doesn't mean you can't, because if you can speak English, you can let it be known your wishes.
Correct.
So there isn't really an excuse in that regard, and most people don't use it as an excuse. It's a fear-based reaction to anything legal. If you can write a letter, or you can get somebody to write a letter for you, and you dictate it to them, your words and your language are perfectly sufficient, provided you give the court the information that you need to give them.
Correct. Yeah.
It's not that you need to go and look for a template, because templates don't work. They do more harm than good.
No.
There isn't a template for your letters.
There isn't. But having said that, equally as well, if people wanted to, we put out probably one article last week and another one before that. The articles will give you a very clear direction in lay terms, so to speak. Now, obviously, sometimes we're guilty of using some big words or whatever it might be, but we do purposely try to break down stuff so as people from the lay perspective, including ourselves, can get a comprehension of what is going on and how to put things together. So the last article we put out, we put a lot of work into it, and as you're aware, Lionel, we spent maybe 3 or 4 days over a long weekend trying to pull it together, and we would hope that it was fairly clear for people to read. Now, for people's reference, if they wanted to look at the actual High Court appeal, the judgment itself, I'd suggest if they do a High Court search under, this is the reference number, 2014/88CA. That's 2014/88CA. And of course, if people want to get onto our mailing list, if you go to thecommonlawsociety.com and they specifically request, could we have the article on the appeal case in the High Court, we'll send them a link to the article as well if they want to explain it. And
one kind of final question before we wrap things up, Des. With regard to, say, the negative side of this judgment and the fact that we've identified that Justice Murphy essentially gave testimony on behalf of the plaintiff, that's not a dead or duck in the water for anybody who might be brought into the High Court, say, because that can be challenged in itself, can't it?
Absolutely. That in itself, as its own point of law, is something that can be challenged. And if, say, I was the defendant in this case, I would be challenging the actual judgment of the judge, specifically in relation to that point. Now, they don't have to challenge the whole judgment, but they can actually challenge the point of law that was made there. She breached the law because she gave clear direction to the bank to go forward. Now, beyond that, if, say, the bank you're dealing with decide not to bring you into the circuit court and decide to go into the High Court, there is a whole plethora of jurisdictional issues which I'd hope we do a full radio interview on and discuss. Because jurisdiction is not just about the fact that the circuit court didn't have the right to hear the case. It goes beyond that as well. Jurisdiction goes into the legality of the processes of the court rules themselves, which we covered comprehensively in another article we did a few months back. But that's perhaps an interview we should discuss once we've done a bit more research on it and get it out on air, because jurisdiction, if people get into their heads a knowledge and a comprehension of what jurisdiction is, there's so much you can stop the bank on in terms of jurisdiction. And
we've seen over the past year or so in particular that when jurisdiction is examined and applied to cases, that's something that can send the banks or the judiciary running scared, because it's something that it's almost like a Pandora's box. You open that up and it can cause a whole host of problems, not just in one case, but with regard to precedents.
Well, exactly. Recently, as you're aware, Lionel, as well, we've had a case whereby we've had a judgment, an order from the circuit court that was found in favour of the defendant, whereby they struck out the bank's case in their entirety. They struck out the whole civil bill for possession, not because of the issue of this jurisdictional issue we're talking about, but because of bigger issues in terms of the lies that were told and the fact that the affidavits that the banks lodged were not correct, and therefore the bank did not have jurisdiction to go in on the form of the affidavit that they had.
Yeah.
So we actually have achieved orders from the bank that strike out cases in their entirety. So this is all...
That's pretty huge.
Oh, it is huge. But again, the media, like, this is probably one of the reasons we're doing this little radio program, I suppose. The media did not cover this in any context whatsoever.
Yeah.
You know, I did a trawl through the internet after I heard about this case. It was sent to me privately by somebody else, and I did the trawl through the media. You know, I checked every paper, physically as well as online, and there was nothing about it.
Yeah.
Absolutely nothing. The only information I got was from private sources, and that was it. Mm-hmm. So, you know, the media are not prepared to cover this. The broader media. I know that this media format would be, and there is other smaller media formats that are prepared to cover it.
Yeah.
But certainly the likes of the national papers, the likes of the national television programs, radio shows, they will not cover this stuff, because it actually does empower people. If you get this information into your head correctly, you actually have the power then to go in and stop the bank and stop the courts.
And that's what it all is about, because the issue of power, and anybody who knows me knows that I speak about power quite a lot and feel very strongly about it, because we're born, I think, with an inherent power, and we're governed only by natural law, and it's only through ceding that power and granting the power to others who can then do harm to us in a lot of cases with their man-made law with the small l as opposed to natural law with a capital L, if you like. Well, that's where the problems arise. So let's take that power back, because once we do, it ruffles a lot of feathers, and it becomes more and more empowering as we continue this journey, not just through our legal battles and legal cases, but through life, because it opens up, certainly my eyes, to a whole lot more beyond the law and to what's going on around us. And the more you can learn about it, it's like that old adage, know thine enemy. The more you know about what's going on, the more you can empower yourself or re-empower yourself. And remember who we really are and what we should be doing, as opposed to what we're told to do and indoctrinated with.
Well said, Lionel. I couldn't have said it better myself.
Well, it's been great chatting to you, Des. It's enlightening as always. I'll be looking forward to our next chat, and thank you very much for joining me. Is there anything you'd like to tie up with or summarise, or maybe you could give the online portals or website again for people who would like more information?
Yeah, well, just for basic connection, I suppose. If people go to thecommonlawsociety.com, put in a name, email address, and if they want specifically these two articles that we briefly discussed, we'll send them a link to the articles, and thereafter they'll get our weekly, monthly mail shots that we send out, and hopefully everybody can learn a little bit more. And hopefully I'd ask the listeners as well that when you get this podcast, or be it on YouTube or whatever, that you share it, you send it out to all the people on the island and let people know what's going on. I think this is a very important point at this stage. The more people that know about this specific issue at this point, it'll educate them a little bit more. You can spread it around a bit more. You're going to be helping people that are in the courts by giving them, maybe you don't need this information yourself, but definitely I'd be very sure in saying this, that you would know somebody else who has got difficulties in relation to mortgages. I think everybody knows them.
No question about it. And as somebody who is independent myself, as a man, independent from the Common Law Society, I rarely do this, but I actively endorse any of the classes or the articles that are running and ongoing, because I personally have learned so much from attending the classes and from speaking to you on a regular basis, Des, and from even doing these podcasts and some of the mini-series that we have done online. It's, as we said, empowering information, and there's no bad can come of it.
I don't think so.
I mean, if people can take it or leave it, that's down to the individual, but there's some really, really good information, and a hell of a lot of it there that people can use for themselves and can pass on to other people. So I actively endorse it, and that's why I'll continue to have these chats and continue with this CLS series. And all that's left to be said really is thanks a million for joining me again, Des.
Thanks very much, Lionel, for having me, and again, thanks very much for your powerful endorsement there.
Fantastic. We'll talk again really soon.
The CLS Talks.